Adams once said, and I quote, "Learning is not attained by chance. It must be sought for with ardor and attended to with diligence." Good morning, one and all. I, Purvika Chandanam, the founding editor of IP Matters, extend my warm welcome to the respected dignitaries on the panel and my dear participants present here. Today, IP Matters is organizing the virtual panel discussion on building a career in IP law. And we have with us Dr. Abhishek Chakraborty, IP academician, Mr. Sanjeet Hegde, trademark attorney, and Mr. Kiran Betadapura, patent attorney on the panel. We are extremely honored to have you all, and I extend my warm welcome on behalf of IP Matters, sir. IP Matters is a student run initiative that aims to create awareness about intellectual property law. We seek to create a robust online forum for productive discussions relating to contemporary issues in the field of intellectual property law. Today, we have IP experts themselves who would be giving insights about the practicalities of IP field. We would be now commencing the session with the discussion on IP academia and research by Dr. Abhishek Chakraborty.
Completed his PhD in 2018 from University of North Bengal. As a research scholar, he has extensively researched in the area of music piracy in film industry. His articles on various issues of intellectual property law, majorly in the field of copyrights, have been published in reputed journals of the country. He has taken extreme interest in educating students about IP law, and in the university, he is involved in.
Okay. Thank you, and good morning once again, all in one present here. So I have around 30 minutes left, right, Purvika?
Yes, sir. Yes, sir.
Okay. So, right, because of this particular arrangement of the panel discussion as well as the initiative on IP matters, I am really happy and I appreciate it. Okay. So on that note, we'll start my presentation on IP academics. Mainly, I will be speaking on research and what are the main type of arguments which we take in IP research. Just give me a second. I'll be sharing my presentation. Okay. Purvika, if you can confirm whether the slides are visible or not.
It is visible, sir. We can
okay,
see.
so, right. So I'll start my presentation. Right. Okay. So I'm supposed to speak on what are the major skills that a student should acquire while researching in the field of intellectual property, to talk about the orientation about IP research and career in IP academics, and as well as what are the useful resources which we can have in respect of researching on intellectual property law. We use the expression assistant professor. So when you are joining particular institute, teaching learning university, you are joining as an assistant professor, and then based on the promotion, you become associate professor and senior professor. Now, that is the major aspect of the teaching aspects of intellectual property. Also, in addition to uh, have a PhD degree, you are also required to pass the national eligibility test, the NET exam, to qualify for the teaching post in a university. So that is the major path in respect of joining academics, and that is also equally applicable for IP, and it is same for other discipline as well. So I will be talking about being a part of academician. We see that research is an integral part, right? So we need to compulsorily have a PhD degree. So you need to research on that. When you are joining as an LLM student, you have to write a dissertation. So research is very much necessary there. And when you are teaching, needless to mention that in this present age, teaching has to be oriented with research. Teaching without research is absolutely will be meaningless in the present age, in the present generation. So the basic orientation should be the teacher has to research continuously and to update himself or herself and convey the same to the students. So research is integral there also, right? And with the famous, as per the famous saying that either we publish or perish. So as an academician, it is necessary to publish research-based articles and writings. So that's why research is inevitable. So in that context, I will not be talking about research methodology here. I just wanted to give certain clarification, because research methodology in intellectual property law and other branches of law are one and same. So I'm not talking about the research methods or the methodology here. I will be talking about what are the special concerns which we need to keep in mind when we are researching on any issue pertaining to intellectual property law. That would be my major concern, because academics in IP law and academics in other branches of law or other branches of social science are one and same. But if you're writing a paper on an issue pertaining to intellectual property law, or you're teaching intellectual property law, what are the major areas, what are the peculiar areas that are unique to the domain of intellectual property law? That would be my major area of concern. And also, I wanted to clarify that I will not be going about the basics of the subject, because I understand that it is a discussion focused on what are the major concerns for research. So I assume that the participants here have a working understanding of the major branches of intellectual property law, and they're well conversant with. So how we can go for a detailed and in-depth analysis of the contemporary topics in the field of intellectual property law, that will be my major concern. So summarizing what I'm going to present today, I will be talking about what are the basics of IP research, what are the checklists you need to have before you are starting on researching on an issue in respect of intellectual property law. You need to also understand that while researching a matter on IP, you need to understand the basic concepts of each forms of IP. So I will be talking about the rationale behind major forms of IP, but here I will not be going in details about all the statutory requirements in details. In order to explain that how building a concept in IP is important, I will be explaining the second point. Now, the third point is the major emphasis which I'll put on. What are the major types of arguments in intellectual property research? And what are the main types of argument? What are the major category of argument? That will be my concern. And at the end, I will be talking about certain important resources for a researcher while researching on intellectual property rights. Some of the, it's mainly in information, already it's there in public domain, but I will be giving certain more inputs on the same. Now, starting with what's intellectual property, I understand that the participants have joined this particular webinar because they know what is intellectual property and they are interested about intellectual property. So I would not go in details in talking about what is intellectual property, but in short, it's a unique value-adding creations of human intellect. Unique because if you are not adding something new to the existing form of literature, then intellectual property protection is not given. However, the standard of uniqueness varies depending on the type of the particular IP. For example, on copyright, it is originality. For trademark, it is distinctiveness. For patent, it is novelty. And of course, it has to have some utility, and it's a product of human intellect. That's why it's a handiwork of creative mind, and that's why the nature of intellectual property is it is in the form of an incorporeal property, or as we call it, intangible property. So according to Salmon's classification property, intellectual property resides in the category of jura in re propria, that is the rights which are intangible in nature. Now, understanding the basic nature of intellectual property is important because when you're writing a research paper on intellectual property, explaining these foundational concepts give depth to your research paper, right? Especially if you're doing a fundamental research on any of the concepts of intellectual property, this explaining the nature of the type of intellectual property, especially if you're talking about free riding aspects of intellectual property, explaining the nature of intellectual property becomes important. So a good research paper should always talk about the fundamental basics of the type of intellectual property and the nature of intellectual property. Moving on, when you are planning to write a research paper on intellectual property, or you are planning to have a research project on intellectual property, as well as if you are going to teach intellectual property in a classroom, these are the three major areas which you need to focus on as a sort of checklist before you start that particular activity. Now, the theoretical justification or the philosophical and jurisprudential background of the topic needs to be established very properly. I'll try to give an example. In the area of intellectual property, there are major three grounds, major three philosophical justification. The first one is the Bentham's, the utilitarian justification propounded by Jeremy Bentham. I mean, I'm not going to the details of the theory, but I'll just mention what are the major justification, and I'm sure most of you are aware of it. Secondly, the Lockean labor theory, or which is also known as the natural rights perspective, which justify intellectual property protection. And thirdly, the Hegelian perspective, which talks about that every property is the notional extension of the personality of an individual. For example, if you are writing a research paper on moral rights, so if you are justifying the claim of moral rights, your paper should contain a discussion on the Hegelian perspectives of intellectual property protection. That would give a sound justification to the claim which you are making. Especially if you are arguing for a new type of property protection, or a protection of a new type of property work. In that case, the utilitarian perspective as well as the Lockean justification plays a crucial role. For example, you want to say that whether sports moves can be considered as performances, or whether sports persons should be considered as performers or not, and whether they are eligible for IP protection or not. In that case, you can take the help of the philosophical justification in the form of the utilitarian theory, or in the form of the Lockean property right theory. There are certain topics on intellectual property which are majorly based on economics. I mean, there is no form of IPR which is not having an IPR angle. But for example, if you are trying to write a research paper on the interface between intellectual property law and competition law, and you are, for example, you are trying to research on whether the functioning of copyright societies are violative of the provisions of the Competition Act in India. In that case, explaining the economic rationale behind the functioning of copyright societies becomes very important. So in an IP research, it is very important to explain the economic rationale behind the protection of that particular form of IP. You need to have a fair understanding, a fair basics in the fundamental concepts of economics. For example, the division between private goods and public goods, the free riding problem, basic concepts like transaction cost, opportunity cost, Pareto optimality. So all these concepts, wherever applicable, has to be discussed, right? That gives much more in-depth analysis to your research paper. And the fundamental concepts, which I'll be talking in the next few slides. For example, you need to know that what type of work, what type of property comes under what respective forms of intellectual property. So you need to make your basics in respect of the respective forms of IP very clear. For example, you should know that what is the subject matter of copyright protection, trademark protection, and patent protection, respectively, or designs or geographical indications. So having a firm grip on the understanding of the requirement of the particular form of IP protection as well as the subject matter of IP protection is very important. I have mentioned that summarily in the next few slides. For example, patents is nothing but a limited monopoly to encourage production of utilitarian works in exchange of immediate disclosure and ultimate enrichment of the public domain. Of course, I'm not going to explain details. But if you're writing a patent law, so you need to make this basic concept very clear. Then only your argument about, say, if you're researching on gene patenting or patenting of life forms or on genetic engineering. So you need to be very clear about what can be patented, what cannot be patented, what qualifies to be an invention, what does not qualify to be an invention. Moving on to copyright, limited, although relatively long-lived in comparison to patent, it's a limited monopoly to encourage the authorship of expressive works because copyright is given to expression of idea, original expression of idea, not to the idea itself. So it has to be in the form of expression. It was primarily developed initially as a means of promoting publishing. So you need to have a good understanding of the basics of copyright. Trademarks, we know that it's a perpetual protection for distinctive non-functional names and dress, which includes trade dress, in order to improve the quality of information in the marketplace. So the economic rationale becomes very clear here. Right? One of the objectives of the law of trademarks is to have information symmetry in the market. Why? To make the position of the consumers better off in the market, as well as to help the consumers in fetching the products which they want to buy or which one they want to consume. So that is the basic underlying motive of law of trademarks. Trade secrets is based on freedom of contract, and it's a means of protection against unfair means of competition. Trade secrets is a very emerging field of research in India, considering that we do not have any sui generis legislation in respect of trade secrets protection. However, there are certain forms of law which are existing to protect trade secrets, mainly in the form of law of contract. By way of law of contract, there are certain provisions in the Partnership Act, and mainly trade secrets are protected through non-disclosure agreement. There exists a huge opportunity to research on the accommodation of trade secrets protection within the existing IP regime, right? Many of my research scholars are working in this particular area, and it's a very important and contemporary topic. Now, moving on, the next part is for which I will be paying substantial attention, focus on this particular segment, is what are the major types of arguments in IP-based research. Now, having your fundamentals made clear in respect of theoretical justification, in respect of economic rationale, in respect of the fundamental concepts behind the rationale behind each types of IP. Now it is important to see that what are the major types of arguments which are made in intellectual property research. Now, basically, there are mainly three types of research which we see. First is conceptual, right? I will be explaining that in the course of the discussion. Second is analytical, where you are applying or you're analyzing a particular provision of law. And thirdly, there are empirical research. So you have a data and you need to prove your claim based on those empirical data. But here I have categorized the major types of arguments in IP research into 5 categories, and I'll be explaining the 5 categories here, right? My focus here is mainly on theoretical as well as, or a doctrinal study here. So if you are doing a theoretical study, what are the major arguments which a researcher in IP-based topics make? The first category is the arguments in respect of inclusion of a new type of work. You know that the field of intellectual property protection keeps on evolving, and it will keep on evolve, and that's the most fascinating aspect of intellectual property law, as well as all other disciplines of law as well. But you see that with the growth of technology, there are creation of new types of work, and that poses a challenge to the existing IP law, that whether they can be protected under the existing form of IP protection or not. You know that in India we have specific legislations on the respective forms of IP because of our obligation under TRIPS. And it depends on the definition of the type of IP and also determination of the subject matter of the respective forms of IP. For example, under copyright law, there are 6 types of work which is recognized, and it's a closed type of definition of work, right? No longer a right? My major focus will be in respect of copyright and trademark here. So you see that I have kept certain illustrations, certain examples here. For example, protection of sand art, culinary presentation, street arts and graffiti, tattoos, 3D printing, as well as non-conventional trademarks. So whether these can be protected under the existing IP law or not. Recently, you have observed that I think many of you know that the retail store layout of Apple has got a trademark in the United States. And that gives rise to the question that whether the retail store layout can have a trademark, whether it can be protected under trademark protection or not. So it comes under non-conventional trademark. Many of you will be knowing that the image of the Taj Mahal hotel in the Nariman Point in Mumbai has got a trademark protection. So it's very fascinating to see that how the definition of mark under Section 2(1)(m) of the Trademarks Act has been expanding, and newer forms of marks are being included. The major non-conventional trademarks are the color mark, scent mark, then the taste mark, etc. So when you are arguing for these newer types of intellectual property, you need to keep in mind the basic concept. For example, in case of copyright law, you need to look into the concept of originality. You need to look into the concept of fixation, which is very crucial in the protection of copyright. Right now, whether it has an author, whether the work is authored by someone. So these are the 3 main requirements of copyright protection. So you need to have an analysis, you need to make an argument that whether these forms of intellectual property, these types of new type of work can be protected under the existing forms of legislation, IP protection or not. Now, I'll be giving certain illustrations here. If anyone can write in the chat box what I am referring to here. Okay, I will not be able to see the chat box here, but anyways, so I'll be explaining what this is. So this is one of the most discussed street art or graffiti by famous street artist Banksy, which is there in news a few days before. Actually, Banksy lost the suit on trademark law, mainly because he didn't want to reveal his identity. That's why he didn't want to fight that particular litigation. So that much importance he gives to his privacy. So he wanted to have a defeat. He doesn't mind a defeat in IP litigation rather than revealing his own identity. So what I'm talking about is a street art or graffiti, where the street art or graffiti can be protected under copyright law. So this whether this can qualify to be an artistic work. considering that most of the street art are considered presently as illegal works. Whether they can be protected as a copyrighted work is a big question. So there is an opportunity to conduct a research here, right? In United States, there is a specific law, for example, Visual Artist Rights Act, VARA. So that specifically deals with this kind of situation for the protection of street art. In India, we do not have legislation other than copyright. We do not have any other guidelines other than whatever is there in the Copyright Act. So we're talking about the inclusion of a new type of work. So this is one type of argument. Next, this is known as the spiral jetty, right? It's a sand art, right? I'll give a background of this image. Robert Smithson, it's an artwork Spiral Jetty. It's located at the Rosal Point Peninsula on the northeastern shore of the Great Salt Lake, Utah, in the United States. Now, using over 6,000 tons of black salt rocks and art from the site, Smithson formed a coil of which is 1,500 feet long and 15 feet wide that winds counterclockwise of the shore into the water, where the sand art can be protected as a copyrighted work, as a work under copyright law. Next, on your left-hand side, you can see the image where there are two famous personality. So I hope all of you are getting in what context I'm trying to explain. For example, on your slide, on the left-hand side, there is a image from the movie Hangover, where you can see that the actor has a Maori tribe tattoo in his face, which is very similar to the image on the right, which is there in the face of Mike Tyson. We see that the same Maori tribe tattoo is there. Tattoo is there. So I hope you're understanding that I'm talking about tattoo as a form of copyright protected work. And there was a litigation in the United States, although it was not decided and it was settled outside the court. But then it raises important question as to the fixation aspect of copyright law. So whether human skin can be considered as a medium of expression, right? If you go to Spicy IP, there are many blogs on this. These arguments on protection of tattoo becomes important mainly in respect of the video games. Very recently, there are many litigations which are pending in the United States against the manufacturers of video games, against EA Games and others who are developers who use the same tattoo of which is there in the skin of the respective player, and that is there in their video game, and that's why copyright infringement suits have been filed. So it raises an important question that whether tattoos can be considered as an artistic work under Copyright Act. On your right-hand side of the slide, you can see that there is a bottle of perfume. So in European Union, there was one particular decision where the fragrance was held to be a subject matter of copyright protection, although later it was, but then it is also a type of non-conventional trademark. So here the question is whether fragrances can be a subject matter of IP protection. Few years later, the taste of cheese was claimed to be. Is there anyone who wants to say something? Okay, so there was a copyright protection claim over cheese, the taste of cheese, which was rejected because it was not considered to be a subject matter of IP. Now, this is very interesting. So in your on your left-hand side, you can see that there is a tweet by a famous chef called Duff Goldman, and he tweeted during the beginning of the presidency of Mr. Donald Trump. So he made this tweet that the cake on the left is the one I made for President Obama's inauguration 4 years ago. The one on the right is Trump's. And he claims that he didn't make it. Okay, so the news is like this. So during the inauguration of President Obama's presidency, this particular cake was made. You can see the decoration there. And the staff in the office of Donald Trump made the same claim, went to the same bakery, and they requested for the same cake which President Obama had. I'm not going to the political aspect of it. I want to remain within the domain of IP here. But then Duff Goldman didn't claim any copyright protection. And you can see from the emoji that he's wondering that whether he can claim an IP protection. So that gives, and on your right-hand side, you can see the famous salmon cornets. I'm forgetting the name of the chef who has developed it, and as well as you can see the Vietnamese pho noodles, right? Now, this raises question as to whether the culinary presentations can be subject matter of copyright protection. The decoration, the manner in which a particular food is being presented, whether that can qualify to get IP protection, right? So again, the fixation concept, the subject matter of copyright becomes very crucial here, right? Purvika, I just want to know how much time is left for my presentation.
So in another 10 minutes, I think you can.
Okay, okay, fine, okay. So this is an important aspect where the question comes is whether culinary presentation or the manner in which the foods are being decorated, whether it qualifies to be to get copyright protection or IP protection in general. So you are making, in this case, you will be making arguments in respect of inclusion of new type of work. But you need to keep in mind that the three basic concepts, that it is to be authored, it has to be fixed into a tangible form, and it should be original, right? Now, the fixation requirement of copyright law has always been controversial. What do you mean by copy? What do you mean by a tangible medium? Has not been clearly expressed in none of the international conventions as well as in the domestic laws. I mean, except in United States Copyright Act, not many legislations on copyright protection has a definition of copy. So that keeps the question open-ended, that whether this type of subject matter qualifies to get IP protection. This is what I was talking about recently. In the United States, the USPTO, the United States Patent Trademark Office, has granted a trademark protection over the store layout. The retail, in this case, you see that this is the representation of the Apple store. So it has got a trademark protection. Not only Apple has got this particular trademark protection over the layout store. There are other instances in United States that under Lanham Act, there are registrations given to the block or the store layout, right? So this gives rise to a question that whether this store layout qualifies to be a mark under Trademarks Act, right? So this is again another a new type of non-conventional trademark, or you can say that whether it qualifies to be trade dress protection, right? So it is evolving. So here you will be making an argument in respect of whether this new type of work can be protected under IP law. Now, that being the first type of arguments which you make in intellectual property research, the second major category I want to talk about is the application of law, where you will be interpreting certain provisions in the respective statutes. You see that in the first type of argument, it was mainly conceptual research, where you are arguing for whether a new type of works can be protected within the domain of intellectual property law. In this second category, we see that here we are arguing for on a particular provision. So you are interpreting a particular provision in the respective statutes. In the respective statutes, I refer to as Trademarks Act, Copyright Act, Patents Act, Designs Act, etc., etc. Now you are trying. Of course, the task of interpretation is given to the court, to the judiciary. But here you are analyzing certain expressions in the statute. Now, why we are doing that? The basic purpose of research is to, dispel the uncertainty, is to remove the ambiguity which we have in respect of understanding of the law. So research is required when there is an uncertainty in the law, where there is a gap in the legal framework or in a particular law, where there exists uncertainty in the understanding of the law by the court, or there had been many cases where the court have not correctly applied the law. For example, the Penguin Publishers case under Section 14 of the Copyright Act, where the Delhi High Court gave a per incuriam judgment in respect of the parallel import of copyright protected work. So the second type of argument, you are trying to analyze certain provisions in the statute or certain expressions in a given statute and trying to understand what are the uncertainty how the ambiguity or the shortcomings are existing in the law. So I have selected certain examples in the second type of arguments which you make in IP research. This example I already gave, that where the sports moves are considered as performance, as well as whether sports persons can be considered as performers. You know that performance rights are protected through Copyright Act 1957. Now, whether the definition of performance is given in section 2 clause Q, and the definition of performance is given in 2 clause WQ. Now, it is open-ended definition, and that's why it becomes an important subject matter of research, that whether we can consider performance sports moves as performance. There are both arguments on both the sides. Those who are pro IP, they say that it involves creativity. It involves the labor of the particular person, so that's why it is a protection. On the other hand, it says that it is not fixed into a tangible form, and it is the de minimis rule should be applied. So that's why the sports move should not be considered as performance. It is debated that whether a particular mannerism or particular shot taken by a cricketer, for example, the helicopter shot or the dill scoop, whether this qualifies to be protected under Copyright Act, right? Or the way a particular sports person celebrate their success, whether that can be considered as performance, whether they can be considered as performers. You can see the way the Caribbean players, the cricketers, the way they celebrate taking a wicket, or Usain Bolt, the way he celebrates after he finishes a sprint. So whether that can comes under the domain of IP protection. So here you are interpreting, you are trying to analyzing a particular provision here, or a particular definition, that is section 2Q or section 2QQ of the Copyright Act. Right here, you are not arguing for a new type of work, inclusion of a new type of work, but you are trying to understand that whether the definition of performance includes sports moves or not. Secondly, especially in view of the recent case, I think 2 years back, the last year maybe, the last year, the case, the litigation between Super Cassette versus Super Cassette versus Wink Music has given us to many questions as to what qualifies to be a broadcaster under Copyright Act, because there's no definition of broadcasting organization under Copyright Act. Problem is, if under section 31D, an OTT platform is or internet streamcasting platform is not considered as a broadcasting organization, they cannot apply for statutory licensing. So there exists ambiguity in the understanding of what do you mean by broadcasting organization under section 31D of the Copyright Act. That's the problem. The problem is mainly because there is no definition of broadcasting organization under the Copyright Act, even though broadcaster rights are secured through the provisions of Copyright Act. So there exists a shortcoming in respect of what amounts to what is a broadcasting organization. There's a definition of broadcasting, there's a definition of communication to the public, but there is no definition of broadcasting organization. Interestingly, the Bombay High Court in the Super Cassette case held that internet platforms cannot be considered as broadcasting organizations. However, the office memorandum issued by the Copyright Board said otherwise, and a recent amendment is pending, which is supposed to come this year, where definition of broadcasting organization includes internet platforms. So there exists a conflict between the decision of the Bombay High Court and the proposed law. So that is there because there exists ambiguity in respect of what amounts to broadcasting organization. The next example I put as text and data mining. I will not be talking about the technology in details, but whether the use of TDM mechanism considers can be considered as fair dealing under the Copyright Act is a gray area. This question has become much more pertinent because of the JNU data depot, which is developed by two scientists. One is Professor Lin, and the other one is Professor Karl Malmudé. So both of them are working on this TDM. So it makes academic research much more meaningful, much more fast. But it involves reproduction of someone else's work. And every time you cannot take consent of the other publishers. So in that context, whether text and data mining mainly for academic research, whether that qualifies to be a fair dealing, is important, very much important, considering that European Union and especially United Kingdom's the Copyright Design Patents Act, last year they have amended their copyright law and has brought a specific exception in respect of TDM. So whether TDM is can be considered as fair dealing under Copyright Act, we do not have a certainty. So here you will be interpreting the respective provision in Section 52. You'll be analyzing the respective provisions in Section 52. The next example I've kept is, the scandalous or obscene marks are considered as absolute grounds for refusal of trademark registration under Section 9. So it mainly depends on the discretion of the registrar. So it's an absolute ground, right? So that's why the argument is that whether refusing to register a trademark on the ground that it is scandalous or obscene, whether it violates the freedom of speech and expression. In the United States, there are two leading case laws where it has been held that the refusal of the trademark registration by the USPTO was held to be violative of the First Amendment right. So whether the same can be true in the context of the Indian jurisprudence, that is a very crucial question. Sorry. The next example is the uniform factors for determination of generic marks under the Trademarks Act 1999. You know that one of the clear instances where the trademark cannot be registered or trademark should not be registered is that if a trademark becomes generic. Whereas the Trademarks Act lacks specific guidelines as to what amounts to generic mark. So in that case, what can be done is if you can look into the judicial decisions and can see that whether there has been any uniform criteria as to determination of generic marks in the absence of specific guideline under Trademarks Act as well as trademark rules, right? So what had been the judicial understanding of generic mark? Is there any uniformity as to what factors lead to makes a mark a generic mark? That can be a subject matter of inquiry. Overlapping between copyright and designs protection, many of you must be knowing because of the provision of Section 15, and because of the overlapping nature of the protection between designs and Copyright Act, it is confusing that what exclusively comes under Copyright Act and what comes under Design Act, and that has led to loss of protection in many cases. So here you see there is a conflict between two forms of IP, and there had been substantial progress in the United Kingdom because understanding that there will be a confusion. Initially, they were protected under separate legislation, separate sui generis legislation. Now they have been brought under CDPA. So whether in India we should do that, because Copyright Act was enacted in 1957 and Designs Act was enacted in 2000. Now, in the statement of object and reason of neither of the legislations are clear about their actual scope and ambit. So that's why the conflict between the copyright and designs protection can be a relevant subject matter of inquiry. Now, the last two types of argument is the personality-based argument and the liability-based argument. In case, what do you mean by personality-based argument? I have given the example of AI here. So it's a very pertinent question that whether artificial intelligence AI can be considered as an author under Copyright Act, because the Copyright Act talks about CAW, that is computer assisted work, and the law is very clear on that. But the Copyright Act is uncertain as to what would be the situation in case of CGW, that is computer generated works. So what could be the argument behind recognizing AI as an author, because the definition of author under Section 2 Clause D does not clearly tell us whether artificial intelligence can be considered as author. But investigating into this field requires an understanding as to the nature of personality of an AI, whether they are considered as legal person. So that's why it's a personality-based argument, that whether they can be person under the respective legal framework, and until unless they are considered as person, whether they can be considered as an author, or without considering them as a person, can we confer authorship on on artificial intelligence? And if authorship is conferred on AI, what would be the consequences can they claim damages in a trademark in a copyright litigation? Whether themselves they can register a suit? All these questions are unanswered. So that's why research is required. Next is in respect of patent law, based on the same personality argument, whether AI can be considered as true and first inventor under Patents Act, because of the same problem under Section 6, that whether who can be the definition of true and first inventor under the Patents Act is not clear as to who can be an inventor. It only says the interpretation of the word person becomes crucial here. So when you're making a personality arguments, mainly in case of AI-based topics, you are making a personality-based argument. And the last type of argument, I mean, this is not an exhaustive list. These are some of the major types of arguments which I have observed, right? Where the last type of argument where you're trying to ascertain the liability, where the liability of a concerned person is not clear. For example, the first one, the liability of ISP for copyright infringement. So whether the ISP should be considered as liable for copyright infringement for sharing third-party infringing copyright material is a question. That the one argument is that they are providing the platform, that's why they should be held responsible. The other argument is that they are made they are only made a scapegoat of the situation, so that's why they should not be held liable for copyright infringement. So because of the conflicting provisions between Section 79 and 81 of the Information Technology Act, and on the other hand Section 51 of the Copyright Act, there exists uncertainty as to the determination of liability in respect of ISPs. So especially after the Delhi High Court decision in the case of MySpace versus Super Cassettes Industries Limited, this topic has gained significant importance. And another instance of this last type of argument, that is the liability argument, is the liability of copyright societies for violating provisions of I'm sorry, there's a typo here. It should be violating provisions of Competitions Act. I think it's 2002 Competitions Act, specifically abuse of dominant position. You know that Section 33 of the Copyright Act permits having a natural monopoly in the form of copyright societies, whereas the purpose of competition law is exactly 180-degree opposite. It does not allow to have a monopoly. So on the one hand, the Copyright Act allows to have a monopoly by way of establishing copyright societies, and they can determine the licensing prices, and they can have an absolute monopoly on that particular area. But according to Section 4 of the Competition Act, no entity should be abusing its dominant position. So can the functioning of copyright societies under Section 33 make them liable for violating Section 4 of the Competition Act? So this can be an argument. So where you are examining the conflict between two types of law, because there is an exception for IP infringement in respect of Section 3 of the Competition Act, that is in respect of anti-competitive agreements. IP intellectual properties are recognized as an exception there. But in case of Section 4, that exception is not there. So you cannot argue that IP-related matters cannot be applicable for Section 4. So a natural monopoly conferred by the provision of one legislation, whether that is infringing or violating the provision of another act and making them liable, can be a subject matter of inquiry under the liability-based argument. So these are the major 4 type of argument which you have seen. Main argument in type of inclusion of new type of work. Second, application, interpretation of specific provisions in the respective statutes. Third one is the personality-based argument, and the fourth one is the liability-based argument. These are the major types of argument which you make, right? So moving on to the last segment of this particular presentation. What are the major resources for research on intellectual property law? Here, I have divided this segment into 3 categories: databases, websites, and intellectual property blogs, right? I intentionally did not mention any book here because there are many leading books on intellectual property law, and most of you will be knowing about it. I'll be talking about the other resources. So I'll be talking about some of the very important databases, and I'm sure many of you already know about it. Just as a refresher, you can go through this. The first one is an open access database, Journal of Intellectual Property Rights, right? It is maintained by CSIR, And please note that this is the only Scopus indexed IP journal from India, right? This is the sole Scopus indexed IP based journal originating from India. There are other Scopus index journals like Journal of Intellectual Property Law and Practice that mainly publishes content related to EU law, that is published by Oxford University Press. And there are other Scopus indexed IP journals as well. So this is an open access database. You do not need to have any subscription. You can just type Journal of Intellectual Property Rights online. I have put the link here. I can share this with IP Matter. They can distribute among the participants. So you can have an access to this particular open access database, and it contains a wide variety of topics on all types of IPR, and they are very, very much authoritative, detailed, and analytical in nature. The other databases, they are mainly subscription based. The other three I have mentioned here: LexisNexis, Bloomberg Law, and the third one is the Intellectual Property Law Collection, which is the part of Hain Online. I'm sure many of you have this access to these databases from the university. If you are, because they require subscription, you can request. If you're not having access to them, you can request the library department of the respective authority in the university to subscribe, because these websites, these databases are very, very much important for IP-based research, right? LexisNexis have patent analytics, they have IP portfolio, and there are other products also which they offer. So in respect of intellectual property oriented material, they have a good collection. And the same is the case with Hain Online also, but Hain Online mainly contains material in respect of US intellectual property law, but they are very much authoritative and helpful. Next, I have mentioned some of the websites of the official websites here. The first one is the official website of Intellectual Property India. So it comes under the Comptroller General of Patent, Trademark, Design, and Geographical Indication. I'm sorry, I forgot to mention the Copyright Office website here. So Copyright Office has a separate website. So all the relevant fees, all the relevant forms, and the present developments can be found in this particular website. WIPO website is, I have mentioned the WIPO website. Most of you, I think all of you know about it. So this is the official website of World Intellectual Property Organization. It contains a huge resource on intellectual property. Needless to mention that this being the head of the main agency of International Agency of Intellectual Property Protection, the materials are very important. This is, again, Fine Law for legal professionals. Intellectual property is a good website. Intellectual Property Office of United Kingdom, United States Patent and Trademark Office and their website, and European Union Intellectual Property Office and their website. The link is mentioned here. Now, if you want to know that what are the non-conventional trademarks that they have registered, you can go to these websites and find out in their respective tabs that what are the new types of trademarks that they have registered. For example, there's something called motion mark, which is in the jurisdiction of European Union Intellectual Property Office, right? And there are other instances, so that will be helpful. And lastly, IP blogs. Again, please excuse me for my biases. These, according to me, I found these blogs to be very resourceful and very effective. There are other important IP blogs as well. This I found to be very relevant for my own research. As a matter of fact, IP Matter itself is an IP blog, right? So I have not exclusively mentioned here, right? And I regularly go through the blog entries uploaded by IP Matter. But say IPWatchdog.com, Law 360, then Intellectual Property Watch, Intellectual Asset Management, IPCAT. These are the international IP blogs. IPCAT mainly contains blogs related to intellectual property issues in the jurisdiction of European Union. Needless to mention, Spicy IP. It contains all the relevant and contemporary developments in the field of intellectual property development in India. Banana IP has its Synapse IP program where they regularly update the contemporary developments. So this is a very useful resource if you want to keep yourself updated about the contemporary development of IP and want to conduct research on that. So these are the major IP blogs. Other than that, there are many other important IP blogs as well. So I think, okay, this will be my last slide. So I'm not sure how many of you are aware of this. If you want to go through specific case studies on intellectual property, WIPO has an excellent collection of case studies based on specific types of IP and based on specific themes. So all you have to go is to this particular URL, follow this URL. You can go to this particular segment of WIPO, that is case studies on intellectual property, which they call as IP Advantage. So you can have case studies on trademark law, patent law. You can use this as a mode of teaching. You can use this as a mode of research as well. So it contains databases. And the last thing I want to mention is the open access IP material. I have mentioned about 2 links here, especially in this pandemic time where access to library becomes difficult, and many a time we do not have access to databases which are subscription based, where you need to buy a particular database. In those scenarios, these open access IP materials are very significant. So there are 2 links I have mentioned here. So both is there in the Spicy IP blog. So they talk about the IP books which are open access, as well as other materials, and from where you can find them. So all the IP case law text, as well as other texts, for example, on trademark law and copyright law, all the cases and materials can be accessed. So only the open access content are mentioned here. So if I'm sure many of you are not able to have actual access to library, and of course remote access is possible, but even after remote access, if you feel that you are looking for some more content, these are open access IP material, which I found to be very relevant. So I'll stop my presentation here. Thank you, Purvika. Thank you, Jahnavi. Thank you for this opportunity, for sharing my understanding and my experience on research in IP. Thank you very much, IP Matters.
Thank you very much, sir. Thank you for your inputs in the IP research field. Sir has been our IP professor at Christ University, and he has been motivating students like us to be actively participating in the field of IP. Thank you for motivating us, sir. Even IP Matters was also an initiative that me and Jahnavi took up because of the enthusiasm that you have created for us in the field of IP. Thank you very much. Thank you for your input.
Thank you, Purvika. Thank you.
Now, moving on to the next session, I'd like to invite Mr. Sanjeev Hegde, the trademark attorney, to give us a brief about career prospects in the field of trademark and copyright law. A brief introduction about Sanjeev, sir. Mr. Sanjeev Hegde, who is the senior partner at Banana IP Councils, Bangalore, leads the trademark, copyrights, media and entertainment, and IP licensing and transaction practices of the firm. Prior to Banana IP, Sir has worked for some of the leading Fortune 500 companies such as Archer Daniels Midland and EMC Dell in an IP advisory, licensing, and transactions capacity in the United States. He holds a master's in intellectual property, commerce, and technology, and a Juris Doctorate degree from Franklin Pierce Law Center, United States of America. Sir has diverse experience advising clients on IP strategy, transactions, licensing, monetization, and dispute resolution in technology, entertainment, and digital industry. His clients include Anand Audio, Dharma Productions, Essilor, Peps Industries, and Bosch. From time to time, he has also advised selected startups and SMEs. Mr. Sanjeev sir is regularly called to deliver lectures at leading institutions of the nation, such as National Law School, Bangalore, Indian Institute of Management, Bangalore, and Gujarat National Law University. He is also the creator of the popular online IP and legal education initiative, Hegde Simplifies, which disburses simple-to-follow guidelines to students and professionals through YouTube and other social media channels. Sir, we are extremely happy and honored to have you with us today. Over to you for presentation.
Thank you, Purvika. Hello, everyone. Good morning. Good morning. I hope, well, actually it's afternoon. So good afternoon to everyone. Nice to have all of you here. Thank you so much. Fantastic presentation by Dr. Chakrabarti. Very insightful. And Janvi for putting this initiative together to have a lot of law students, and I understand there's also some faculty members and working professionals who are listening in on this presentation. I'd like to now share my screen, and Purvika, let me know once this comes up. I am audible, right? You're all able to hear me.
Yes, sir, you are audible.
Okay, share screen, present now. Is this visible?
Yeah. No, sir.
It's not visible, huh?
Yes.
How about now? Is my presentation visible?
It's not yet visible, sir. Do you want me to present it? I have it on.
Yeah, go ahead, Purvika. Yeah, that'll be easier for me.
Okay, sure, sir. Just a moment.
Okay, wonderful. Yeah, it's come on the
Thank you, sir.
screen. Yeah. So, what IP Matters has asked me to speak about today is career prospects in particular to copyright and trademark law, areas that I get a chance to work with. A different perspective, slightly from than what Dr. Chakrabarti has spoken about. He spoke about the academia perspective, a research perspective. Whereas me coming from a law firm, an IP law firm, I am more on the transaction side, I am more on the dispute side. So you get a sense of these areas of IP laws, right? Copyright and trademark in particular, and the kind of work that an attorney or a professional in these areas, the kind of work that they get to do. Next slide, please, Purvika. Thank you. So I was just putting, the employment possibilities for copyright and trademarks laws in terms of areas, type of organizations that you can work for, and I made a list over here. You all might be familiar with these as students. You might be looking for internships in some of these organizations, and you, as some of the professionals who are here, you might be working in these kind of agencies. Primarily, and this is kind of a de facto ranking that I provided here, and that wasn't the intention, but that's just the way this has worked out. In terms of employment opportunities in trademark and copyright, it's primarily in law firms. Good number of law firms will be looking for people with IP backgrounds to be able to do IP work. After law firms, you're seeing a lot of corporations, and this is an area that most law students or new working professionals are not aware of. Typically, your thought is, I'll go try to prepare myself or get employment with law firms. But surprisingly, good number of jobs today are available in corporations as related to IP, particularly copyrights and trademark related job opportunities. Good number of NGOs are working in this area. Government agencies are also hiring people with IP backgrounds. Last but not least, academia, where you have a lot of opportunity in terms of research, and you also have a lot of opportunity in terms of teaching. Next slide. Okay, so basics. Dr. Chakrabarti has done a great job in terms of covering some of the IPs. I'll just talk about the two domains I am speaking about today, trademarks and copyrights, right? What are for everyone's benefit. Just quickly, when we're talking about trademarks, we're talking about words, symbols, or phrases that represent a particular product or a service, or they represent the products or services of an organization or the organization's name. Branding, essentially, right? The purpose of these words, symbols, or phrases is to distinguish the products and or services from your competition, from somebody else, right? That's the purpose of branding. I want this particular name to be known with me and my products, right? And you can have your own names. I don't want you to use mine, right? I want that level of distinction for my products and services. And also, lastly, it identifies source. So when you see a Tata car on the road, when you see a Maruti car on the road, you know there's a difference. That is a Tata product. This is a Maruti product. So it identifies source. This is essentially, in a nutshell, what trademarks is about. On the other hand, you have copyrights. And in copyrights, it's original works of authorship, right? So what are these original works of authorship? Like literary work, right? Something that you've written, stories, it might be film. The entire film is called a cinematographic film. Music is called a sound recording, right? Where music is recorded. Then there's various types of artistic works. It could be a painting, for example, and also things like advertisement. These are also considered copyrighted works. So there is a question of expression versus idea, and Dr. Chakrabarti has touched on this. So I just want to make a quick distinction here. So an idea itself. Suppose you have an idea for a article or for a film. That idea itself is not protectable. However, when you put that idea into the form, say you write a story based on your idea, or you make a film, or you make a music video based on that idea, it becomes expression of that idea. That is protectable under copyright law. And that is what you're getting protection in terms of being able to stop others from using it without your authorization or without your permission, such as license. Okay, next slide, please. Okay, so I titled this Circle of IP. It's kind of like Circle of Life. I don't know if anyone has seen The Lion King, but I just happened to lift this title from there, Circle of IP. What I'm trying to essentially give you an idea of here, right? In the middle, you see this image. You see a Swiss Army knife, right? In the chat, can you give me a sense of all the IPs that might be involved in this product? Quickly, if I can get, and Purvik, if you can just read it out to me, what people are typing out. Can you tell me, you might have seen this product, right? This is a Swiss Army knife with multiple different tools that are foldable into this casing, right? What are the different type of intellectual properties do you think are involved?
Sushant Murthy says design, logo, and utility.
Okay.
Matav says patent and design.
Okay.
Vaibhav, industrial design.
Okay, very good. Anybody think copyrights? Maybe. Okay. Well, essentially, all of these different IPs that I've mentioned over here are part of this product. That's why I call it the circle of IP, right? Meaning, all of these different types of IP have to go hand in hand. I know I am particularly talking about trademarks and copyrights now, but when you look at this product, when a company conceives this product and they want to manufacture and they want to put it out and they want you to buy it, they want you to pay money for this, there's various types of IPs involved. So idea is this: copyrights and trademarks don't work in isolation. As you can see from this product, the utility of this product might be protected by patents. The design, right? The look and feel of this product are protected by something called industrial designs or designs, right? The branding, you see that kind of a plus symbol over there, right? Or where it says Swiss Army, those are the trademarks, right? Those are the words, the symbols of this organization. And then you have copyrights, a lot of the material. So this image itself that I put over here is a copyright of someone who's clicked this, right? And I haven't taken permission right now, so I hope nobody reports me for having taken this image right now. However, the organization which makes this product will have a lot of will have a lot of collaterals that they build for the marketing, for example, this image, writing, they might make videos as to how this product is used and such things. These are all protectable under copyright. Then obviously there's an element of trade secret, right? There's certain things about how you make this product, right? That you might not necessarily want to reveal, or you have particular contractors that you're working with who are providing you parts for this, and you don't necessarily want to reveal who these contractors are to your competition, so they don't go to them, right? Those are trade secrets. Idea here is all of these work together hand in hand in making a product successful, a service successful. Today, we're talking about copyrights and trademarks, but they have to work with trade secrets, patents, designs, and other areas of law. This is the inner circle. On the outer circle, if you imagine, you have other areas such as IT laws, which would apply to this. You have data protection laws, which would apply to this. You have e-commerce law, which might apply to this. You have competition laws, which apply to this. So these are the next circle outside the inner circle of IP that I've mentioned over here. I just wanted you to get a sense from this that all of these work not in isolation, these areas of law, they work hand in hand with other areas of law as well. Next one, Purvika, next slide, please. Okay, so particularly to trademarks and copyrights, and this is based on my experience, I just want you to start seeing some company names so you can associate this with the employment opportunities and possibilities. One thing I want you to be aware, the second slide I showed you, or the third slide, I think, where I mentioned where are all the types of organizations where you can get jobs. Law firm is the first one over there. And a good number of law students or fresh graduates, when they're looking for employment opportunities, the first place they will go look usually is law firms. What I want you to be aware of is, like I said, law firms in terms of trademarks and copyrights isn't the limitation. There's a lot more opportunities out there. We have to understand the business of the various areas that we might want to work in, right? And you will realize that the opportunities are not limited to law firms. So let me give you an example. For example, trademarks. Let's talk about the FMCG industry, right? Fast moving consumer goods. You know, this industry is one of the highest filers, prosecutors, right, of trademarks, meaning they file the highest number of brand names in a given year. And branding is very important for them in terms of the promotion of their products, the sale of their products. So for example, ITC, right? Fast moving consumer goods, food related products. You're familiar with ITC, right? All the products that are in your local grocery store, when you go there, each of them is a brand, right? So under the ITC umbrella, you have so many hundreds and hundreds of trademarks. So they're in the business of creating these brands. They're in the business of protecting these brands, and they're in the business of promoting these brands. Law firms and trademark attorneys like myself, aren't the only ones who are working on this. So FMCG like ITC will have a collection of lawyers who have expertise in trademarks law, will be working on the branding strategy for the company, the protection of those brands, right? And also monetization of those brands, putting it to market and making money from it, right? So good examples are ITC and Patanjali. Patanjali has become very popular lately. They started with, I think just ghee. But these days, as you know, they're into everything. They're even claiming to have a solution for corona, right? They come up with a medicine that happens to be a solution for corona. Next, there's a content industry, which does a lot of trademark work. When I say content, as you can understand, it's any kind of content, right? It can be music, it can be film, it can be written content, right? All of this content. So some examples are, for example, Dharma. Purvika mentioned earlier that I have an opportunity. I work with Dharma, right? So Dharma Productions is who I'm talking about, right? They make a lot of films. They make a lot of music. And these days, they're making a lot of digital content that is going to go onto platforms like Hotstar, the next example I've given you over here. Hotstar, as you're aware, has been rebranded recently. I think it's Disney Plus Hotstar. That's what they call these days, right? But content, right, also has branding involved. Each of the titles of the content that's created, for example, a movie, right? That title, you can file for a trademark. And that itself becomes an asset of that organization. Next, you have a lot of trademarks involved in the electronics industry. Simple example, Samsung and Apple. Samsung and Apple have many brands within those umbrellas, right? They have products and services that they offer. Each of those are protected by brands, trademarks. So just like the FMCG, ITC industry, ITC and Patanjali, electronics companies also put out a lot of brands that are significant in terms of trademarks for them in terms of doing the business that they do. Lastly, one quick example, pharma and cosmetics. So you have something like AstraZeneca. AstraZeneca right now is working on the corona test with the Oxford University. The corona vaccine, right? AstraZeneca is a very big pharmaceutical company. Something more familiar for us, say something like Himalaya Drug Company that we have in India. So they also have a lot of branding related activities. A lot of the sub-brands under their umbrella, they're looking at protecting these and monetizing on this. So this is a quick snapshot for you in terms of industries in India, according to me and my experience, where branding or trademarks, more specifically, are very significant for the type of business that they do. FMCG, content, electronics, pharma, and cosmetics. Next, let's talk about copyrights, right? Where are copyrights significant and what are the types of industries that I know, right? In India, particularly, that copyrights is a significant part of the work that they do. So you take IT and digital industry, right? So IT is someone like TCS. TCS is the largest IT services, IT products company out of India, right? So they have a lot of copyrighted work. As you all might be aware, software, which is code, right? Code is protectable as a written work, similar to a literary work. So it's protected under copyright law. If that code is included as part of a product and that has some utility, it could be protected under patents. But primarily, code is protectable, right, under copyright law. So TCS, someone like TCS, copyrights becomes very significant for them. Facebook, right? These are digital. So Facebook is in the business of uploading and managing a lot of digital content, and that digital content is usually protected under copyrights. So these are your photographs, these might be your songs, these might be videos that you make, right? This might be a lot of the creative information that you're taking and you're uploading on Facebook. They're in the business of managing all of these copyrighted works. Next, the media and entertainment industry. I wanted to give you some examples here where copyright is very significant. Have all of you heard of a company called Green Gold? Okay, I'll tell you quickly in terms of what Green Gold. Green Gold is out of Hyderabad, and Green Gold is the maker of Chota Bheem, right? So this is kind of a Disney model, right? Disney has created a lot of these characters over the years, or Marvel, right? Marvel has a lot of superhero characters, right? Like that, Green Gold is our local, our Indian brand that has created Chota Bheem. And Chota Bheem, right? The content that's created in terms of what we see on TV is under copyright protection. But Chota Bheem also goes crossed into a lot of merchandising. They make products based on those characters they've created. So trademarks is also significant for them because that trademark, in combination with the copyright, they make products out of this and they put it to the market, such as the little dolls. Right? I have a daughter, so I'm familiar. I go to these toy shops and I see Chota Bheem products all over the place. Purvika, have we lost our screen? Hello, Purvika.
Is it not visible, sir?
Yeah, I think it's disappeared. I'm not able to see it. I don't know about others.
Just one moment, sir. Give me one moment.
Yeah.
Sir, there is some internet issue. I'll be connecting in a while, sir. Just a moment.
Well, let me try to share my screen once again, see if that works.
Okay.
Okay.
Yes, sir. It is visible right now.
Okay, great. Okay, we were here. Everyone able to see? Okay.
Yes, sir.
Okay, lastly, I'd like to speak about the publishing industry, right? Publishing, you're familiar with Times of India, and one of the major publishers around the world, Google. Google does a lot of Google News and such publication. So these are all types of works, which I mentioned earlier, what is protectable under copyrights, right? These guys, like the Times of India and the Googles, are dealing with publishing. Point in pointing out to you all of these industries is so you get a sense that law firms are not your end result ultimately for employment, right? You have to start thinking broader because there's a greater opportunities even outside of law firms, right? And it's primarily in industry. So these are all the industries that currently are dealing with trademarks and copyrights in India. So that's the sense I want you to get. Okay, quickly, I'll give you some examples of the work that I do as related to trademarks and copyrights. So you can kind of picture yourself doing these when you have an opportunity in the future. And in my introduction earlier, as Purvika, the introduction she provided about me, as you heard, I have worked for many organizations prior to coming to the law firm, right? So I never had the intention of working with a law firm when I came out of law school. And most of the opportunities I had at that time were in organizations. So I've done a lot of IP transactional work, right? It's a mix of not just legal, but a mix with business, right? It's a business, it's a mix of business in the sense of product development, in terms of sales, in terms of marketing. Along with it, I have applied my legal skills. So these are things that I still continue to do. And as related to trademarks and copyrights, here's an example of what you might get to do, right? If you happen to come into this domain in the future. So examples, will start with trademarks, right? Currently, I'm working on something called a global trademark watch for an electronics brand. So this electronics brand has a name, right? Has a trademark, which is a popular trademark. However, they have a lot of competition that's coming out of China right now, where the Chinese competitor is copying the trademark of the electronics brand that I'm working with. And they're going and filing trademarks in as many as 40 different countries, where they want to enter these markets and restrict the entry of my client, right? The electronics brand in those markets. So what we do is we have various mechanisms, various tools, which will monitor the various IP trademark databases of all of these countries and will notify me, right, whenever anybody files for a trademark and which gets published in that country, and before it gets granted, it gets published, right? So that's a notification. So I receive that notification, and then we make a determination, are we going to oppose this trademark from being granted in that particular country? And then what is the process, right? I will contact our foreign partner. We will work with them in terms of filing oppositions. And if it's already a granted trademark, then we might file a case or something called a rectification. So idea there is to stop the competitor from entering those markets and keeping us out, because they're essentially copying our trademarks, right? So this is something called a global trademark watch. So you're helping the client protect that brand and helping them create opportunities for entries into new markets because of the significance of the trademark that they have, right? So that's called a global trademark watch. That's one of the activities I'm doing. Next, I got to work on a collaboration between a very well-known cricketer and a smartwatch products company here out of Bangalore, right? What do they want to do? Well, the celebrity is tied up with a couple of big name shoe companies and garment creators. And these the celebrity has a brand with the shoe manufacturer. So they wanted to lend that brand, that trademark, to the smartwatch maker, because they see that smartwatches are also connected to the exercise or the athletics industry, where they're already making shoes and they're already making clothes, right? So this collaboration basically is a trademark license, right? It's a license collaboration that we are working on. So what would you work on here? Would you look at the terms of what the celebrity is giving as a trademark license? What are the conditions? How much are they charging? Are there royalties involved, right? Will the celebrity be doing promotions? On the other hand, celebrity is concerned about, well, how good is the smartwatch brand? Has the product been tested, and is it refined enough where consumers would want to buy it? What happens if there's an issue? There's there's some kind of a product liability issue, and I end up getting sued. My name looks bad. Who handles that? So this is another aspect of collaborations as related to trademarks that we get to work on in the trademark domain. Next, an example of trademark portfolio building, right? So I work with a very large sleep products company. They're into mattresses, they're into bed sheets, they're into pillowcases, they're into curtains, all these things that go into or related to your sleep at your bedroom, right? So trademark portfolio building is the exercise that we would go through. We have created close to 80 trademarks they have created 80 trademarks. We're in the business of protecting those trademarks and keeping an eye in terms of misuse of trademarks in the industry, right? Ultimately, these 8 trademarks create a valuation for the company. The company is now looking at possibly in the next couple of years, where they're looking at merging their business with a larger player, maybe an international player, or they're looking at being bought out by a competitor and such. So that trademark portfolio that they've created has to create value for them in terms of the valuation, right? In terms of the monetary valuation that they receive when they go into this stage of merging with someone, right? There has to be a rupee or a dollar sign associated with each of the trademarks that have been created. So we're in the business of creating these trademarks, protecting these trademarks, and keeping an eye on misuse, unauthorized use, and pursuing those unauthorized use in the market. Because this client of ours is a very popular brand. And they're a leader in their industry. They have the largest market share. So a lot of the competitors will come out with products which are similar to them to be able to receive benefit from the popularity of our client, right? Because they want to look like them. They want to seem like them. So as such, we also have to take that effort in terms of stopping those competitors from misusing the brand or getting unnecessary benefit which they don't deserve. Okay. Next, brand licensing. So for example, a film. So we worked with a very well-known film production house where they made a very popular film. So trademarks, how it works is you have to, when you file for a trademark, you have to claim that trademark in the line of business, meaning the product or the service that you want to use it for. So if I have a trademark, for example, my firm is Banana IP, and we are in the legal business, right? We are in the legal services business. I can't tomorrow go use Banana IP to manufacture cars, right? That's a different line of business. Unless I go apply for a trademark in that line of business and that trademark is approved. So what large organizations, very popular brands, what they do, like this film production company, the film title was very popular and everybody wanted to be a part of it, right? So we filed for trademarks in the film category, but we also filed for trademarks in many other products and services. And then we got into this business of giving licenses, for example, to that trademark to others who wanted to use it because that mark was popular, right? So example, someone wanted to use the name of this film for tires, right? They wanted to launch a line of tires which had this trademark on it. So we needed license from the filmmaker for that because the filmmaker has gone and filed for a trademark in that product or services category. And they want anybody who's using that trademark to come back to them and take a license to be able to use it. That's an opportunity. You're creating an opportunity, a financial opportunity, a monetary opportunity for the client. So like that, we gave out licenses for tires, we gave out licenses for rice, we gave out licenses for garments, we gave out licenses for services, many different areas because of this branding strategy that was put in place. The product initially might just be a film with that title, which is protected by trademark. However, because of the popularity of the film, there was opportunities to expand that trademark into other lines of business where you could control and give licenses and reap the benefits of the popularity of your film. That's through trademarks is another aspect that I work on. Quickly, infringement dispute resolution. So dispute resolution, you all might be familiar as lawyers, as law students. This is the first thing that we think about what lawyers do. As you've seen from all the examples I've given you prior to dispute resolution here, right? A lot of them are business related, right? And you trying to figure out, for example, the first one was an electronics brand. Second was a celebrity endorsement. Third was a portfolio building exercise. As you can see, you have to understand the business of these clients and how to use trademark or their benefit in terms of building their brand. That's what trademarks is about. It isn't limited to just dispute resolution, meaning we have a trademark, someone has copied, now I'm going to sue you, or we're going to go court, we're going to litigate it, or we're going to have ADR, alternative dispute resolution. Those are elements of it. But in my experience, it's less than 5% of my time is spent in dispute resolution as related to trademarks or other IPs that I'm involved in. But primarily, a lot of the work is advising clients and taking care of these things like Global Trademark Watch, right? Go to market, and protecting the trademarks of a sleep products company. These are the things that I get to do in trademarks. Dispute resolution is when, as I had mentioned earlier, the sleep products company, for example, we have a large portfolio. So if someone does use the brand without authorization, then we get into the business of sending legal notices. We get into the business of negotiating with them if they're willing to negotiate. If they think they're right and they're not willing to stop their activities, then we might have to litigate. That is the second aspect, and that's a very small aspect of this line of business. Okay, now I'll speak about copyrights, give you some examples there, and then I think I'll be pretty much done. I would have covered this area. Copyrights, for example. So like I said, even here, right, litigation or takedowns or dispute resolution is just a very small element, probably about 5% of the work I do. What are the other things that I do as related to copyrights? For the first example here, open source program, right? I was working on an open source software program, contribution program for automotive company, a very large global automotive company, wanted to create a software program where contributors from all over the world could contribute their code. Okay, so when we talk about open source, there's proprietary software, something like Microsoft, what you're using, like say Microsoft Office, right? Microsoft Outlook, Word, Excel, all of these are proprietary. They're protected by Microsoft. Only they usually build the code and they put out the product. Whereas open source is something like Android, right? Google Android. Many people can take that code that's been developed and they can contribute their own piece to it, or they can use it and make their own apps. They can make whatever they want with it, right? As long as some level of recognition or credit is given back to Google Android for having given that code. So this large automotive company wanted to get into something like Android, where they have an open source program and related to automotive tech, where contributors from all over the world can contribute their code. So as I mentioned, code is generally managed, protected under copyrights. So we had to look at all elements of open source licenses, copyright protection, other forms of IP and such, and put a program in place, create a program where they could execute this, the client could execute this, and they could start receiving contributions about automotive technology from various people from all over the world. So this is something that we got to work on. Next, copyrights related, we're working with a record label. A record label is basically, the term means it's a music production company, right? They're also into artist management. So this particular record label company, without naming them, I can tell you that they're into EDM, which is electronic dance music. They're into hip hop and rap, right? They are particularly focused on the Tamil industry, right? So most of the rap, hip hop, and EDM music that's coming out by them is in the Tamil language. But it's not restricted to that. They have global artists from Singapore. They have artists from UK and Germany. They have artists from US and many, many artists from India who are being managed by them in terms of the services that these artists provide, right? So the record label will help find employment opportunity for the artists to be able to sign with, say, a music producer who might be making music for film, or maybe making that music for, say, a gaming app, right, and such. So the deals that has to be structured for the contribution that the artist gives. The artist might be a producer, meaning a music producer who creates the notes, might be a lyricist, one who writes all the lyrics to the music, or might be a performer themselves. So how do you manage, right? How to manage the contribution of this artist, and what rights do they get ultimately in the end product, which is copyright protected? This is also something that we look at. We work with this record label. Some other examples. So digital news aggregation. We work with a very well-known app, which basically takes news content from all the publishers across India in as many as 12 or 13 Indian languages, and they collect it and they aggregate it on an app where you can see all news as related to a subject matter in Kannada or Hindi or Tamil or Bengali or any of these languages that concerns you, right? So this news aggregation business, again, is related to copyrights, because those news creators, right, the original publishers like Times of India or Economic Times, are the ones who own the copyrights, right? So what are the licenses that they need to give to the app? And what are the things that the app can do in terms of taking that content, manipulating that content, editing that content to be able to display on the app? So this is another aspect of what we do as related to copyrights. Quickly, OTT co-production, OTT, over the top. These are basically, OTT represents things like Netflix, Amazon Prime, Hotstar, right? Where you're streaming a lot of content. So because of Corona, the number of production by that I mean content being created to go on OTT platforms has significantly increased. So at this time, we are working with content makers, short film makers, digital series makers, music video makers, who are in discussions with the Netflixes, with the Amazon Primes, with the Hotstars for co-production. So the platforms will finance the making of a film or a music video, right? So we're putting these deals together, and ultimately there's a copyright in the product that's created. So who owns it? How do you share it? How do you make money from it? These are all aspects that we look at, right? Quickly, the last two, nursery rhymes publishing. So we are working with an organization which does a lot of Indian nursery rhymes, and they do it in as many as 7 languages. And now the popular rhymes has gone way beyond India because of Most of these are available online. They're available on YouTube. So we are working on a publishing deal. A publisher who sits out of the UK is interested in carrying the content, the nursery rhymes, and making it available through various platforms, not just limited to YouTube, right? They want to put it on other platforms because they have that reach. So we are working on this publishing deal where the copyrighted content of this nursery rhymes creator is going to be carried by a publisher to the world. Lastly, the disputes aspect of copyrights, right? These might be in the form of takedowns. Takedowns meaning you see some content, for example, on YouTube, someone has posted content, and that's not their content. They've taken it from someone. They haven't taken permission. They've posted it. So you go through a takedown process, and ultimately, if that doesn't work over there, you have to proceed on to more severe dispute resolution mechanisms such as litigation, filing cases, and such. So I'll give you an example of case that we worked as related to copyright. So our client made a very popular Bollywood film. This film, thereafter, a year after, while the same producer was making a Tamil version of this Bollywood film, a Tamil producer has gone and copied the story and made his own version of the film and has released it. So we tried to negotiate with this Tamil producer. However, we were not very successful in trying to convince him that he had copied the content. Thereafter, we had to file a case. We had to litigate. And ultimately, we got a judgment in our favor, which basically said that the entire storyline from this Bollywood film had been lifted by the Tamil producer, and that version of the Tamil film was infringing on the copyrights of the Bollywood film. And therefore, they had to pull the product from the market. And they could no longer be displaying or showing that film on TV or any other places, right? So that is the tip of the iceberg. That's probably about just 5% of the work. Okay, so with that, I've given you a sense of trademarks and copyrights law and the career opportunities that are there and the kind of work we get to do. So in summary, I'd just like to state that as lawyers, please don't limit yourself to think that your employment opportunities might be only law firms, right? It isn't. More and more employment opportunities are in organizations such as these that I've mentioned to you, right? Across various industries where they're looking for people with an understanding of trademarks, copyrights, patents, trade secrets, industrial designs, and such. And they all work hand in hand to be able to protect a product or a service, to put that product or service out, and to monetize it, right? So understanding those various businesses. So if you're looking for internship opportunities or you're looking for jobs, don't just go knocking on law firm doors, but look at industries that you might be interested. Maybe you like the digital media industry. Maybe you like the filmmaking industry, or maybe you like the electronics industry. You're into smartphones. There are a lot of legal opportunities there, and they're primarily related to trademarks and copyrights and other forms of IP. So with that, I close my presentation, and I'd be happy to answer your questions. I think at the end of the next session, there'll be some time for questions. Thank you so much.
Thank you so much, Sanjeet sir, for your inputs in the field of career and career opportunities in the field of copyright and trademark. I've had the opportunity to work under Sanjeet sir's guidance when I had the opportunity to intern at Banana IP, and it was definitely an enriching experience to have worked under you, sir. Thank you so much for joining with us today. And now we have Mr. Kiran Betadapura, the patent attorney, who would be covering the aspect of patent law, advocacy, and practice. I would like to give a brief introduction about Kiran sir. Kiran sir is a practicing advocate and a patent attorney who invests in early stage startups and is a qualified company secretary. He specializes in corporate matters, mergers and acquisition, company valuation, patent litigation, property rights, and international trade law. An industrial engineer by qualification, Kiran sir is an alumnus of IIT Kharagpur and IISc Bangalore. As an entrepreneur, he co-founded and bootstrapped many ventures. In his corporate career, Kiran sir has headed operations for the Birlas based out of California and has served as the head of sales and marketing of banking, insurance and finance segments for HCL Hewlett-Packard in Mumbai. Sir enjoys teaching and delivers lectures regularly in schools and colleges. He is equally earnest about legal activism and constitutional reforms. His first book, Gita and the Art of Selling, was nominated for the Crosswords Book of the Year award. Sir, we are extremely blessed to have you here with us today. We are looking forward to get inputs from you in the field of patent law. Over to you, sir.
Thank you very much, Purvika. I understand we are running a little behind schedule, so I'll try to speed up to the extent possible. Having said that, I know I'm the last speaker today. There is an upside and a downside to being the last speaker. The downside is obviously the audience would be, interest levels and focus levels in the audience would be waning off. But the upside is I get to have the last word, because at home, rarely do I get to have the last word. It's always my wife who prevails on me. On that note, let me just share my screen and then I'll get going. Again, I think we are having a problem. Maybe.
Sir, should I share the screen?
Let me try one more time and then see if it doesn't work. Then you can go ahead and share my PPT.
Mr. Betadapo, this is Sajid. So the issue is when you say share screen, then you have to click on the screen that is showing, then share. Then
no, it
share.
is. Yeah, but share is not even giving me that option. It just gives me, yeah, there you go. Let me see.
Click on that item and then plus share.
Yeah, there you go. Oh, all right. Now, before I start talking about patenting, let me just quickly, and I don't want to obviously preach to the choir here. Let me quickly talk about what is meant by property rights. Essentially, it's a bundle of rights, and the bundle consists of the right to use the property, possess the property, retain fruits that derive out of the property, gift the property, assign the property, alter, make alterations, improve upon the property itself, lend, rent, lease, license. You can even sell the property, dispose of, or even destroy the property. So whenever we talk about property rights, be it copyright, be it trademark, be it patents, it's this bouquet of rights that we are obviously talking about, and classification, we all know about it. I don't want to belabor the point. I'm sure it has been covered in great detail by the previous speakers. Vis-a-vis patent, there is a rationale why patenting is important.
Sir, sorry to interrupt, but your PPT is not visible yet.
Oh, it's not visible, is it?
No.
No, I think you will have to run it, Purvika, for me, because
Okay.
the share button is not enabled on my screen. I think the moderator has not assigned share rights to me as a user. He's disabled my share rights.
Just a moment, sir. I'll be sharing your PPT.
Sure. We just go to slide number 4, or perhaps it's slide number 5.
Should I move forward?
Yeah, you just keep moving forward, because I was already on to page number, or rather slide number 5. Yeah. Now, in terms of rationale, there are two angles to it. No, I think you moved. Yeah, that's good enough. From technology perspective, patenting is relevant because it gives obviously recognition to the inventor, the person who conceived the idea first. And it basically records the original thought that has gone into the idea itself. From a business perspective, a patent portfolio helps encourage investment. Why? Because it protects the idea itself from being replicated or infringed upon by others. And that essentially means that I can leverage the idea in the marketplace uniquely. Essentially, I'm setting up an entry barrier for others to come in and manufacture that particular product or idea and take it to the marketplace. So essentially, it reflects in terms of higher profits, return on investment, needless to say. It also gives me a certain exclusivity. And that exclusivity translates into a competitive advantage. And that competitive advantage gets me to charge higher prices, premium, again, all of which comes back into profits and return on investment. Next slide, please, Purvika. In a nutshell, a patent, once you've been granted, gives you a 20-year exclusivity. It is territory specific. So basically, if I file for a patent application, I file a patent application in India, I am looking to protect the idea that I have, which would all be documented in the claims section of the application itself. It gives me the right to leverage the idea in the marketplace in India. It basically protects the idea itself. There are four, whenever you look at filing a patent application, you need to look at not only the patentability of the idea itself, there are also certain criteria based on which the patent itself, the application gets rejected, which basically would make it non-patentable. First and foremost, the idea itself, the core idea that you have, which you think you've conceived originally, you're the original inventor of that idea, it needs to have certain utilitarian value. It needs to be useful for somebody or the other. It needs to necessarily be original, which means it's novel. And it needs to have it needs to entail a distinctive inventive step. That inventive step vis-a-vis what exists in the world, in terms of, let's say, a state of art or a status quo, needs to necessarily not be obvious. And the idea itself should be manufacturable, which means it should technically be feasible for me to produce the idea and then start marketing the idea. Non-patentability in the Indian context would essentially mean the idea itself should not be frivolous. It should not be a discovery driven, which means the Pluto, 9th planet, that's non-patentable. The idea itself should not be harmful to the public. It should not be an abstract theory like a mathematical algorithm. Anything that is atomic energy related is expressly barred under statute. Admixtures are non-patentable, which means I just mix few ingredients and then I say this is a patent that I've come up with because this mixture has these advantages. That clearly is not permissible, not patentable. Then agricultural, horticultural methods are non-patentable. Any form of traditional knowledge also is non-patentable. Algorithm, I already talked about it. Abstract theory. Can we move forward, Purvika? Yeah. In general, the key, whenever you think in terms of patentability, is the core concept, the core idea behind the patent application that you wish to file, and then have a patent granted to you for. Generally, if you look at the world around you, ideas tend to evolve along distinct avenues. Either, especially in the electronics industry, there is a lot of miniaturization that happens. There is also a drive towards mobility application, which means there is a product that is a tethered product, let us say, and man being a mobile creature, mobile enabling that application or that product itself is one distinct avenue in which products evolve and technology evolves and ideas occur to people and they look to protect those ideas. Mashup, if I have multiple, let's say, systems I integrate those systems and create a mashup, and then I look to file and I look to claim that I am the original inventor of that mashup idea, and I look to protect it. Merging is the same, merging and mashup of distinct systems or subsystems, so to say. Marketing itself can be a basis for protecting ideas that you have, and technology itself evolves along those lines. Classic example being, let's say, personalization, or mass customization of an idea or a product, and that product, that idea itself can be protected. Modification is something that goes on all the time. There are incremental improvements that people come up with for any given product or idea. The classic example being your seat belt, because the seat belt till date has had over 3,000 patents that have been granted on it. It all started with a 2-point seat belt, which means it's a seat belt that is that a harness that is connected at two ends, at 2 points. Right now, we've gone right up to 8-point seat belts. Mechanization, generally, technology tends to evolve from something that is being done manually onto something that gets automated. Mechanically, from mechanical, it progresses to electromechanical, from electromechanical, electronics, and once you have electronics integrated, then there is higher and higher levels of integration that you would want to have. More and more functionality gets added. There is a lot more user friendliness that you put in, smartness, artificial intelligence. That's another avenue in which technology tends to evolve. New materials that people come up with, modern trends in like, for instance, COVID itself is changing the way business is being done. So many people are coming up with new ideas. So there's always something or the other that is happening in the environment. There is constant change, and because of that constant change, people do come up with ideas. Purvika, can you just move forward? Business model, the medium that you use. Like right now, let's say I use the keyboard to key in something. Being able to talk into instruct, like for example, you could use, instead of your keyboard, you could give a command, voice command to your computer, and that itself is an idea that people take and people try to protect all the time. Methods, Kanban, Six Sigma, all these ideas, there is certain extent of patent protection that is possible on these ideas. Purvika? Now, from a career standpoint, if I were to look at all the career opportunities or options that are there, I would look at it as justice seeking, dispensing, and facilitating. From a seeking perspective, I can either be an advocate, and the same thing applies to intellectual property rights, and with specific reference to patents. I can be an advocate, which means I get involved in patent infringement litigation. I can be an activist related to patenting, or for that matter, this is a general slide that I have put up. IP-related matter, for instance, or pleading in a court of law, or a prosecutor, that's typically in a criminal context. Nevertheless, these are all the opportunities that are there. The most relevant one for intellectual property is that of an agent. Now, you would have to pass an agent examination, patent agent examination that the Controller General conducts. And you only, if you have a science degree or an engineering degree, would you be eligible to take up that exam. But the difference between an agent and an advocate is, whereas an advocate can take up a patent infringement litigation matter in a court of law, an agent can only represent a client before the Controller General. So there are also advisory and assertive, basically when you're looking to assert a right. So those kind of opportunities that are also there, corporate lawyer, basically an in-house counsel is right there, up there. And whenever there is a dispute, conciliator, alternate dispute resolution mechanisms are all obviously there. So those are all opportunities that exist as well. From a dispensive standpoint, adjudicative, you're all familiar with it. Being law students, that's what I understand. The audience is dominated by law students, is what I'm told. And facilitating, so academia, and then there are auxiliary lines, administrative lines, oath commissioners, compliance auditors, legal process outsourcing, whole host of opportunities that are there. Some of which may not be very relevant for from the patenting angle, but all these are opportunities that are available to law students and graduates. Next slide, Purvika. If you can just quickly run through the next 3 slides, and then I'll come to the meat of my presentation. So all of this is there. If you have a science background, all these angles, all these avenues are open to you. There are avenues related to the Constitution, the Holy Grail, when it comes to litigation. And then, of course, there are procedural laws that would be applicable. From a patents and design standpoint, you can be field specific, which means basically you specialize in certain verticals that are there. Be it construction, be it energy, there's a whole host of activity, a whole host of patent protection that is going on alternate energy production and generation ideas that are there, using gravitational pull, using solar energy, green. There's tremendous activity going on. Next slide, Purvika. I already talked about this. If you have, let's say, an arts background, again, there are several avenues that are available, not necessarily from an IP standpoint. This is a general slide that I put up. Just keep moving forward quickly, Purvika. Yep. And if you have a commerce background, again, these are all the options that are there available to you. You can become an industry specialist, banking, insurance, securities, construction, etc., etc. Right? Now, yep, keep moving on, please. Yeah. Now, when it comes to patent protection, the best way of looking at patent protection and the opportunities that exist out there is to look at the existing body of patents that are there, that are filed, that have been granted right from the 18th century. You can look at it, you can put them all into 3 silos. Those that are expired, which means the validity is 20 years. So after 20 years, anybody can look at the patent that was granted, that has been granted, and then copy the idea that is there and start marketing the idea itself or the product. Existing is those that are wherein the 20-year time period is still not over. So the rights are still subsisting. So if you if you infringe that patent, then obviously you're looking at litigation action in a court of law, presumably. Expectant of those that are in the pipeline. So they are on the anvil. There are people who have worked on it. They've filed their claims, or there are applications, or they've filed their provisional patent applications. And then it's just a matter of time before the examiners and the office look into it and grant the patent itself. So most people try to focus on the cutting edge technologies, cutting edge products and ideas that are there, and look to be the next wave in technology or in a product, so that much of the market can be garnered. Having said that, the real challenge to patent protection from a business standpoint is focusing on the expired patents, because that's an opportunity. If I'm a businessman or an industrialist, it gives me, there's a whole body of inventions that are there, which I can just pick and choose depending on my competencies, core competencies, and I can straight away go to market without trying to protect it in any way. I leverage my existing manufacturing, the infrastructure that I've created. So it is not just the trying to be the next best thing after sliced bread that patent attorneys should be looking at, or even businessmen should be looking at. They should also look at the patents that have expired, because that can be straight away exploited in the marketplace, right? Next slide, Purvika. So from in my experience, much of patent protection that takes place is transactional in nature. The various lines or various activities that go on in a typical agent's office, or a law firm are all related to patentability of an idea or validity of a patent that has been drafted. Freedom to operate is another line that agents and lawyers are typically generally busy with. You could look at having relationships, strategic partnerships with other companies or other inventors in the same space, and then try to collaborate with them and identify spaces where you have freedom to operate without infringing on the patent portfolio of either your competitor or your collaborator. Then landscape and competitive analysis, that's the existing state of art that goes on all the time. Part of it is also identifying white spaces that exist in the landscape. Claims drafting, this is extremely routine in nature. On one hand, claims drafting itself is routine, but the way you go in, the wordsmithery that you use, the verbiage that you use, there's a lot of creativity that goes into it. But the activity itself is to a large extent very routine, very transactional in nature. Many patent agents and patent attorneys look at it as a postman's job, in the sense there is an idea that an inventor has already come up with. The idea is being put into a certain form and a certain format, and then being filed with the office. Office action, anytime there is action within the Controller General's office, responses to that, and finally infringement search, and making sure that your entire patenting activity is aligned with the business goals and objectives of the inventor itself, if it happens to be a company. If it's an individual, obviously the individual is free to patent protect whatever idea he or she has. Purvika, next slide, please. Now, from a strategic standpoint, and this is where a lot of activity needs to happen, particularly in India, there is very little market impact assessment. An idea or a patent has absolutely no meaning if you cannot monetize it in the marketplace. And that's where, even before you start filing or filling up a patent application, you need to necessarily think in terms of market impact that the idea itself is going to have. Portfolio estimation, the valuation of the portfolio, the IP portfolio, these are all strategic in nature. These are also opportunities that exist for those who specialize in patent filing and patent protection. Damages estimation, anytime there is an infringement, estimating the damages and modeling the compensation claim itself is a strategic activity. Tech trend forecasting, trying to figure out where technology is headed. There are distinct paths. I talked about the 10M paradigm earlier. Identifying a white space and a market niche for you to file your application and protect your idea is key to this entire patenting process. Monetization strategy. Remember, patenting is extremely strategic, which means you never ever go in with a churning the ocean kind of an approach. You would have to look at what exists in the marketplace, look at gaps that exist, try to plug those gaps effectively on one hand, and also tippy-toe around the other patents that have already been filed, applications that have been filed or granted, patents that have been granted. Make sure that you don't, while you're trying to protect your own idea, you don't end up infringing patents of others. Sustainability consulting is another area, and this is not sustainability in the green sense that I've used the term. It is making your own idea and your own leg up in the marketplace sustainable, and to ensure that the entry barrier exists, and because the patent protection that you have, for that matter, IP protection that you have, acts both as it acts as a shield as well as a sword. It's a double-edged. I mean, on one hand, you make sure that others don't get into or don't infringe on your idea. That's part of the shield. The sword is when if somebody really infringes on your idea, you go after them and you litigate. So again, infringement litigation, unfortunately in India, you can count the number of patent-related infringement litigations on your that have taken place on your fingers. So having said that, this gives a very high level, 30,000 feet above sea level view of all the opportunities that exist, not only vis-a-vis careers in law, but also careers with specific reference to patent protection, filing and patent protection itself. Next slide. I'm open for questions now.
One second, sir. Kiran sir, thank you so much for your inputs in the field of patent law. We're extremely happy to have you today with us for the session. Now we'll be moving forward for the question and answer session. Just a moment, sir. I'll be reading out the questions that have been posed. So, Vaibhav has asked whether an LLM degree is a successful career in the field of intellectual property law.
Purvika, shall I answer that question? Or?
Definitely, Abhishek, sir.
Yeah. So it depends on what is your objective. If you can unmute Purvika, Vaibhav asked this question, right?
Yes, sir. Vaibhav has asked this question.
Yeah, Vaibhav, if you are online, if you can unmute yourself and tell me what is your ultimate objective. Okay, I'll tell you directly. If you are interested in teaching, then of course LLM is required. And being in academics, LLM is the first step where we actually conduct research, because LLB, the orientation is made and the law. Of course, there are certain elements of research are there, but then the objective of LLM is to acquaint the students with the skills required for research methodology. This research is inevitable and helpful not only for passing passing the necessary test, but also in teaching, right? So that's why research will be there if either you are teaching or if you are a research associate. Research is inevitable. So LLM is must. LLM is must if you want to be in academics, because if you want to practice, there is no requirement of LLM, but you can have your LLM degree and still you can practice. But if you want to be in academics solely, then you have to get an LLM degree, because now for teaching, as I told you in the beginning, PhD is must. So that's a mandatory requirement. So in short, LLM is must if you want to be in academics. If you want to be in academics. Thank you.
Sir, Suparna Mukherjee has asked you a question. She's asking.
I'll answer that.
Protection, are the protections available simultaneously or are they alternative?
Right. So strictly speaking, they can exist simultaneously, but you need to be clear about the basics. For copyright protection, registration is optional, and for designs protection, registration is compulsory. If you're not registering designs protection, does not acquire. But there is a provision in Section 15 of the Copyright Act which says that if you have created something, for example, an artistic work can be protected under Copyright Act, and it can be protected as a design also under Designs Act. Say you have created a pot, and there are certain designs are there in the form of ornamentation, in the form of some pattern. Now, under what law it will come? It can come under Copyright Act as an artist, as a work of artistic craftsmanship, as an artistic work, and it can be protected under copyright, for which registration is not compulsory. And the same design can be protected under Designs Act, but in Designs Act you are protecting the pattern, not the pot itself, right? So that is something attached to the article. Now, under Copyright Act, under Section 15, if you are producing more than 50 units of that pot, right? So the moment you are creating 51st unit of that particular pottery, something, in that case, you will not be getting copyright protection. Now, what happens is that most of the small-scale producers, they are not aware of this positioning law. Now, when small-scale producers, they will, of course, produce more than 50 units. So what happened? They produce more than 50 units. Say they have produced 16. So what has happened now? Because it has exceeded that 50 ceiling, that pottery will not get a protection under Copyright Act, because as per Section 15, now copyright protection has ceased to exist. It does not apply now. And you have also not registered under Designs Act, because for Copyright Act registration is anyway optional. So if anyone copies your design, you can have a generic common law remedy, but then passing off is not recognized under Designs Act. So registration is compulsory. So you will not get protection under Designs Act as well. So now what is the ultimate consequence? You're not getting protected under Copyright Act, you're not getting protected under Designs Act. Because under Copyright Act, since registration was not necessary, you didn't register it. And because of that, you have registered it under Designs Act also. So in this case, there is a chance that someone, and there had been instances, there had been an allegation against Fab India for, I'm not using the expression stealing, I'm using the expression taking away certain designs of certain fabric creators, the design of them. So that is because we have sui generis legislation on copyright and design, and neither of the legislation is very clear as to what aspect of design is protected under Copyright Act and Designs Act. When you talk about our designs under Copyright Act, are we talking only about aesthetic expression? That is not clearly laid down. Or when we are talking about designs under Designs Act, are you talking about only industrial design? That is also not mentioned. If you see the long title of the legislation, it is only Designs Act. And the statement of object and reason is also not clear. So because of this ambiguous object of both the legislation, this overlap protection happens. But technically and literally, if I have to answer, simultaneous protection can exist. But for copyright, you need not register, and the duration of the protection is different. And for designs, it's compulsory, because passing off as a common law remedy is not available for design. So registration is compulsory. I hope that has answered the question.
Thank you so much, Abhishek sir. There is a question for Sanjeet sir. Sir, they're asking how much is LLM from foreign university beneficial for an IP lawyer who wants to work in a corporation or a law firm? Sanjeet sir, if you could answer that.
And I don't think mine will necessarily be the most popular answer on this, but I don't think it's beneficial very much at all, right? I think once you finish your LLB in India, BA LLB or LLB, get experience, even if that experience is in the form of internships or unpaid employment, or if you're lucky to get paid employment, great, go for it. That experience working in the IP domain will be much more beneficial than pursuing LLM degree, in my opinion, in India or even abroad, unless, as Professor Chakrabarti said, you are interested in going into academia. Experience will always be that much more beneficial than getting an LLM. However, I wouldn't rule out getting an LLM if you are very focused in a particular area and an LLM in that is available abroad, and if that LLM happens to be from one of the top universities, that might give you somewhat of an advantage in terms of employment if you decide to come back to India. However, in terms of immediately after your BA LLB or your LLB degree, to pursue a LLM will not be beneficial. We are hiring people quite frequently, and from our perspective, we are looking at the knowledge of the person. And having done an LLM has shown us that people who have finished an LLM versus someone who has done a BA LLB and comes back to work, they're all starting at the same point. So on an immediate basis, there's no advantage in terms of pursuing an LLM in India or abroad. But down the road, if you want to specialize and you have an understanding with an organization or a law firm that you're working with, that if you finish it and you can come back, they'll give you some kind of a promotion or additional compensation, you can go for it.
Thank you, sir. There's another question. Disha Mittal is asking, how do we get into the law department of media and entertainment sector? I don't know.
Yes. So Disha, you have to ask for it. That's the only way you can go about it, right? So I would suggest, if you're a student, that you start identifying media and entertainment companies that you're interested in. Go on LinkedIn, look at the people who are working in those specific departments over there, or who's the person in charge. Try to connect with them, or through your network. To be honest, every one of the jobs that I've ever gotten has been through network, right? I've never applied for a job and someone's called me for an interview and given me a job. It's always been, I've been referred to places. So build your network, right? Either through your faculty members or others, or your seniors who are working in those organizations, or what. If you don't have any connections like that, look the person up. Look up that particular company's legal head or other departments that you're interested in on LinkedIn. Try to understand that, try to connect with them, and ask for an opportunity to come work there or intern there. That's the way to get it.
Okay. Sir, there is another question. Is there any scope for career in IPR in semi-urban areas?
Yes, it is there. Obviously, urban areas will have more employment opportunities because of the location of firms, law firms, and companies in the larger metropolitan areas. However, I wouldn't rule it out in terms of doing private practice in, say, smaller second-tier, third-tier towns or cities in India. The opportunities obviously will be limited, right? Private practice is possible because work is virtual these days. You can have your client sitting in Delhi and you might be practicing out of a small town in Tamil Nadu, right? So since work is virtual, I wouldn't rule it out. However, if you're looking at being employed with an organization or a firm, unfortunately, most of these are in the major metropolitan areas. And as related to IP, intellectual property, firms are primarily located in the top 5 cities of India, right? So it will be Delhi, Mumbai, Bangalore, Chennai, and Hyderabad.
Sir, Nikita has asked you, wherein you mentioned about generating a trademark for a famous film, not only in the film category, but in several other classes of goods and services. Is this allowed even if your mark doesn't necessarily fall into those lines of classes of goods and services? It's her question. I think
yes, you can file for a trademark and you can mention that you have an intention to use it. You don't necessarily need to be using it when you file for the trademark. So what this film producer would do is they would file for trademarks in all different products and categories, and those trademarks available when other parties approach them because of the popularity of the film. Other parties will approach them and say, I want to use your trademark in my line of business. Can I get a license from you? So that's the example I was giving you, that there was a tire manufacturer who wanted to use that the trademark for tires. There was someone else in the rice category, someone else in the garments category, and such. So you want to grab those opportunities, and you grab those opportunities by filing an application called intent to use. I have an intention to use in the future.
There is another question with regard to the same query, sir. You said that the producers would get the trademark registration in various classes of goods. Because this is something that sounds similar to cyber squatting, where just on the basis of getting the first registration in that class of goods, you would have a claim against a genuine user of that mark. So,
okay, I have read that question, but I think I understood what the question is. So it's not similar to cyber squatting because the law in trademarks law permits you to file for a trademark in a license if you're not using it there, right? That is permissible. That's what I said. It's an intent to use application, meaning I intend to use it in the future. And this is how licensing works, right? You want to, especially if you're a popular mark, there's also something called a well-known mark filing. That's option. That's an option that's available now. A well-known mark would be the likes of, say, a Pepsi or a Mercedes, and such, who have the ability to stop others from using marks that are same or similar in other lines of business, even if they're not there. That is one option. However, if you're not become that popular yet, but you want to book your spot, right? If you don't use that mark in that line of business in 5 years, others can challenge and get that mark, the registration of that mark taken away from you. But if in that 5 years you find someone else who wants to rent it from you, essentially, right? They want to license it from you. You give them a license to use it. Therefore, you're demonstrating use.
Thank you very much, Sanjeet sir. There is a question relating to patent law. If Kiran sir could answer that. If a person has done both engineering and law, does he have to appear for the patent agent exam?
Yes, the person, regardless of whether the person is a science graduate or an engineering graduate, if he has done law, he can obviously take up a case in the courts. But for appearing before the Controller General, for filing of patent applications and defending those applications, you would necessarily have to be a patent agent. There is another reason why you would want to be a patent agent. If I'm a foreign entity, foreign inventor, which means I'm an
Kiran sir, I'm scared you're not audible right now. Hello? Hello?
Ma'am, good evening.
Sir, can you hear me? Kiran sir, your voice is not audible. Sir, I think you've muted your audio. Can you?
Yeah. Hello? Hello? The session complete? Sir, complete or not?
Please mute yourself. We'll let you know. There's a vote of thanks, and after that, you can leave. Please mute yourself till then.
Thank you. Thank you.
Jahnavi or Purvika, can I answer Kshitij's question in the meantime?
Yes, sir. Yes, sir. Go ahead. Please go ahead.
Yeah. So I see a question there that being an undergraduate student, what skills one should gain for better career in IPR? I mentioned that in the beginning of the presentation that there in the undergraduate level, you make your basics strong. So there are three main things which you need to focus on. The first one is you need to understand the theoretical justification behind IPR protection very clearly. So you need to know the philosophical background and the jurisprudential background very clearly, so that later on you don't have to go through the basics. For example, you need to understand the utilitarian justification of IPR protection, the Lockean property rights oriented reasoning of IPR protection, Hegel perspective of IPR protection, and other theories. So all those theories need to be clear. Secondly, the economic rationale behind IPR protection, the public good aspect of IPR and the free riding problem pertaining to that needs to be cleared at the undergraduate level only. And thirdly, the fundamental concepts and the fundamental reason behind each forms of IPR protection. So there are precisely three basic things. First, what is the subject matter? What is the requirement? And what are the rights that are conferred for all forms of IP? So for copyright, you need to know what is the subject matter of IPR protection, what are the rights involved, and what are the requirements for protecting that particular form of copyright. So the same for all these things. So the rationale behind each form of IP and these three things, that is, what are the subject matter, what are the rights involved, and what are the criteria. So the undergraduate level, you can keep these three things ready so that when you go to the next level, you can go for an advanced understanding of IP of a topic. The three things are the theoretical justification, which includes the philosophical and jurisprudential background, understanding the economic background of IPR protection, and thirdly, the fundamental concepts of the respective form of IP. Thank you.
Thank you, sir. I think we'll move on to the vote of thanks. Respected Abhishek sir, Sanjit sir, Kiran sir, and participants. I'm Janvi KM, the editor-in-chief at IP Matters, and it is my honor and privilege to propose the vote of thanks. I, on behalf of IP Matters, extend a very hearty vote of thanks to all the speakers for gracing us with your experiences and findings in the field of IP law. A big thank you to Mr. Kiran Bettadapura sir for sharing his insights and tips on making it in the field of patent advocacy. His talk on 10M paradigm was truly enlightening. Thank you, sir. I would further like to express my gratitude to Mr. Sanjit Hegde for giving an excellent coverage on the practical aspects of trademark and copyright law practice in India. His insights on possible job prospects in for IP professionals in places other than law firms was truly eye-opening. Thank you, sir. And I'm extremely grateful for the talk given by Mr. Abhishek Chakraborty sir for his insight on conducting research in IP and IP academics. It has to be mentioned at this juncture that Abhishek sir is one of the key reasons for the establishment of IP Matters. It is because of professionals like him that many students like me and Purvika have taken interest in intellectual property law. We couldn't possibly express our endless gratitude towards him. Thank you, sir. I would also like to acknowledge Locktopus for working with us in advertising this event, and my partner, Purvika, for a successful organization and execution. Lastly, I would like to thank all the participants who have taken interest in this budding field of law and have assembled here on a Sunday morning to learn more about building a career in IP. Thank you all for your active participation, without which this event would not be successful. I'd like to conclude by quoting John F. Kennedy, when he said, "As we express our gratitude, we must never forget that the highest appreciation is not to utter words, but to live by them." I surely look forward to utilizing the knowledge I have acquired today. I hope all the participants will too. IP Matters will continue to work towards increasing IP awareness among students, and we wish to build an IP network of like-minded people who will work together for achieving this goal. We hope to meet you all soon on that note. Thank you for coming. Thank you for joining on this Sunday.
Thank you, Janavi. Thank you, Purvika. I just
Thank
want
you,
to
sir.
thank IP Matter. I already mentioned that I cannot be happier and prouder of you seeing this particular initiative. And I wish you all the best for your future endeavors. Thank you for
Thank you,
giving me
sir.
this platform for sharing my.
Thank you so much, Abhishek. Thank you for joining with us.
Thank you for joining. I'll be
Thank
sending the
you.
feedback form. Please answer accordingly. Thank you.
Thank you.